Legal Framework for Collective Bargaining, Fall 2022, DePaul University, Labor Education Center. Promoting a transformational labor movement. What else must be done? Next. Part 1. Labor Management Relations Act, LMRA, and that's Section 8D, Duty to Bargain. The mutual obligation of the employer and the representative of the employees to meet at reasonable times and confer in good faith with respect to wages, hours, and other terms and conditions of employment, or the negotiation of an agreement or any question arising thereunder, and the execution of a written contract incorporating any agreement reached if requested by either party. But such obligation does not compel either party to agree to a proposal or require the making of a concession. Next. LMRA Section 8, an unfair labor practice or practices. Section 8A.5, it shall be an unfair labor practice for an employer to refuse to bargain collectively with the representatives of his employees. Section 8B.3, it shall be an unfair labor practice for a labor organization or its agents to refuse to bargain collectively with an employer, provided it is the representative of his employees. Next. Subjects of bargaining: mandatory, permissive, illegal. Next. Mandatory subjects of bargaining: are subjects related to wages, hours, and other terms and conditions of employment. There is a legal duty to bargain if requested by either side. Cannot make unilateral changes, one-sided changes made by the employer unless an impasse has been reached. May strike or lock out on issues considered mandatory subjects. Mandatory subject examples: wages, pay scales, overtime, premium pay, merit pay, incentive plans, bonuses, especially if they have been in effect for a long time and given consistently. Mandatory subject examples: fringe benefits, vacations, holidays, pension, health and welfare benefits, mandatory subject examples: terms and conditions, seniority, job assignments, subcontracting, promotions, length of contract, discipline, just cause, progressive discipline, etc. Union security clauses, except in right to work states or public sector. Dues checkoff, union rights, time off for union leaders, access to members, use of company facilities, etc. Drug and alcohol testing, not for prospective employees where it's permissive. Grievance and arbitration provision. Permissive subjects of bargaining. Are subjects not directly related to wages, hours, and other terms and conditions of employment. Bargaining over them is voluntary. One party may lawfully refuse to bargain over these subjects or stop bargaining on them, even if started. It cannot bargain to impasse, strike, or lockout regarding these subjects. Cannot condition agreement on mandatory subjects on reaching agreement on permissive subjects. Agreements on permissive subjects may be unilaterally changed once a CBA has expired. Now we have permissive subject examples. Ratification procedures. Negotiation ground rules. Internal union matters. Union recognition clauses. Benefits for retirees. Strike settlement agreements, such as allowing strikers to return to work. Illegal subjects of bargaining. These are subjects that are prohibited by law. Examples: clauses that discriminate against a protected class, yellow dog clauses, hot cargo clauses, clause requiring union membership at a time of hire, closed shop, union security clauses in right to work states or public sectors. Bargaining tactic examples. Hold off on agreeing to at least some mandatory subjects until securing agreement on a permissive subject. Example: the Chicago Teachers Union in 2019 held out for permissive subjects such as class size, staffing levels for nurses, librarians, psychologists, and social workers. Use package proposals to combine permissive with mandatory subjects. Timeliness and notice. Onset and duration of bargaining. Labor Board certification of a bargaining unit. The employer must bargain at least 1 full year. Voluntary recognition of bargaining unit. Employer must bargain for a reasonable time. the notice to bargain. 60 days notice by either side of intent to terminate or modify the terms of a collective bargaining agreement. Failure of either side to give notice would lead to a 1-year extension of the terms of the collective bargaining agreement. 30 days notice to FMCS, Federal Mediator Conciliatory Services. Longer notice for healthcare, 90 days, normally 60 days to FMCS. Ban on unilateral changes, strikes, or lockouts during notice period. Worker striking during notice period loses employee status and they can be discharged. Contracts often contain more specific notice clauses. Part 2. You have a duty to bargain and good faith bargaining. There's a duty to bargain. The employer cannot make changes in wages, hours, or working conditions without bargaining with the union. The employer can only make unilateral changes after bargaining to impasse. The employer cannot make changes that were not discussed in bargaining. The employer cannot offer employees conditions better or worse than those offered to the union. The employer must bargain a change in terms and conditions and the effects of those changes. The duty to bargain has 2 exceptions. Union delays bargaining to prevent an impasse. The employer claims economic exigency or an emergency. Must be essential to conducting business. Must require prompt action. Must be caused by events outside of his own control or unforeseeable. Losing important accounts or contracts, supply shortages, competitive disadvantage do not count. There's a good faith concept. The law requires both sides to bargain in good faith with an intent to reach agreement. Parties must agree to meet at reasonable times and places. No requirement to reach agreement. There's also no requirement to be fair to the other side. The parties may, however, use their leverage to bargain for their best deal. Surface or bad faith bargaining. The employer meets with the union as required, but just goes through the motions with no intent to reach agreement. For example, the employer refusing to meet at reasonable times and places, or refusing to give basic information to the union or discuss certain issues. Agreeing on minor issues but stonewalling on important issues. Refusing to agree to common provisions in the collective bargaining agreement, such as seniority. Proposing wages and benefits that are extremely regressive. Rejecting proposals without offering counterproposals or explanations. Reneging on tentative agreements. Introducing new proposals late in bargaining. Let's talk about direct dealing. Here's what the employer cannot do. The employer cannot make an offer to employees it has not made to the union. The employer cannot encourage employees to quit the union. The employer cannot undermine the union's bargaining position. The employer can, however, inform employees of its bargaining positions, the reasons behind it, and bargaining progress. The employer can survey employees' views on various benefits. The employer cannot ask about specific bargaining issues and positions. Impasse, that ugly word. A good faith deadlock is when both sides realize that further bargaining would be futile. Parties may bargain on other issues or break off bargaining altogether. Either side may refuse to meet once an impasse has been reached. It suspends duty to bargain, but does not end bargaining. Either side may make a move to break the deadlock. Once impasses are broken, the duty to bargain returns. At impasse, the employer can impose its last best offer. Avoid impasse. Determining a good faith impasse. Bargaining history. Attitude of employer towards the union. Length of negotiations. Importance of the issues at impasse. Parties' understanding of the state of negotiations. One side declares it will never accept the other side's offer. There's a duty to provide information. for both sides. Unions have a broad right to any relevant information. Cannot declare an impasse on an issue if the employer has failed to provide the union with requested information. Information must be requested, and there's no duty to provide the information voluntarily. The request must include the reason and why it is relevant. The Labor Board uses a broad discovery type standard to determine relevance. The information must be provided if it is probable or potentially relevant. The union has a right to information that is relevant, even if that information can be used for other purposes as well. However, there are limits on the duty to provide information. Cannot unduly burden the other party. Union may have to pay for some administrative expenses, such as clerical or copying costs. The right to financial profit information only if the employer is claiming it cannot afford raises, pleading poverty. Confidential information. The burden of proof is on the party claiming confidentiality to establish that need. Part 3. Unilateral changes. Unilateral changes to terms and conditions of a collective bargaining agreement. The term unilateral changes refers to changes made to the collective bargaining agreement one-sidedly by the employer. There are strict rules and restrictions on imposing unilateral changes, either during the term of a collective bargaining agreement or during bargaining. Unilateral changes during the term of a collective bargaining agreement. The employer cannot make unilateral changes to terms and conditions of the collective bargaining agreement during the life of the contract. Exceptions. If the contract is silent on an issue, if the contract allows unilateral change, if there are required work rule changes, if it involves a relocation or transfer of bargaining unit work, there's a waiver of bargaining rights. Exception 1, the contract is silent on an issue. If the contract is silent on a mandatory issue, the employer must give proper notice and bargain in good faith until impasse is reached before unilaterally implementing a new term or condition. Example, the collective bargaining agreement allows the employer to lay off workers due to a lack of work. An employer may make unilateral change if the CBA specifically allows for it. Exception number 3, change in required work rule. If the employer has new work requirement, such as a new law is passed requiring a new rule or policy, the employer may make the change, but must bargain the effect of such change. Example, remote teaching during the pandemic. Exception 4, relocation or transfer of union work. For example, the Milwaukee Spring number 2 rule. The employer may relocate or transfer union work if it first bargains to impasse. The employer can use threat of a move to extract concessions in other terms. The employer it may be an unfair labor practice if the union can prove the move or transfer is motivated by union animus. Exception number 5, waivers of bargaining rights. Under some conditions, the union might waive its right to bargain, in which case the employer may unilaterally impose terms and conditions. Waiver through bargaining. Waiver through union inaction, if the union fails to act. Management rights clause. These are waivers of bargaining rights. Unilateral changes when the collective bargaining agreement expires. Wages, hours, and working conditions remain in effect until a successor agreement is reached. No unilateral changes are allowed unless bargained to impasse. Exception, union security clause expires with the collective bargaining agreement. Dues checkoff clauses remain in effect. Unilateral changes during bargaining. If parties reach a good faith impasse, the employer can unilaterally impose all or part of its last best offer on an issue at impasse. However, it must be the last best offer. Cannot impose terms not discussed during bargaining. The union may accept unilateral offer or strike. If the union decides to strike, the employer may hire replacement workers. They may unilaterally determine their working conditions. Require employees to maintain conditions of expiring collective bargaining agreement until a settlement is reached. Must continue to bargain in good faith. replacement workers are kept after settlement must receive all terms and conditions of the new collective bargaining agreement.